Dear students, good morning and welcome to Foundations of Law. So we're looking at lecture 2 today. And if you may recollect, in the previous video lecture, I had spoken about the aspects of law in a very loose sense, and we had explored some certain issues that could be foreseen. So today would be more about philosophy and classifications of law. Now, I have received some emails from some students asking me, the documents that I have uploaded or attached in Moodle seem to be quite bulky and they're too much to read. And how much of them should you actually read? Well, as I stated earlier, the lecture notes are the key from the exam point of view, but everything else just basically helps you to understand the topic better. And also a word of advice, well, as lawyers, you'll have to read, and read. There's no escaping that. So if you put in that habit, get yourself in that habit, it's good for you. All right. Regarding the second lecture now, we have philosophy and classifications of law. So initially, I'll talk a bit about just the philosophical aspects and then in more detail about classifications, because there are some aspects about law that you need to be very clear about, and we'll clarify all of these as we go along. Again, remember, this is a foundations of law class. You just learn the very basics of law. You don't become lawyers at the end of this class. You just learn that law is a more complicated thing than you may have imagined. So, well, law, there are different ways of looking at law, but one particular aspect could be looking at it as the foundation of business. And of course, you cannot have a business environment without a legal infrastructure in place, without rules and regulations. And this is what law is especially visible in. There are a lot of these social forces which hold societies together, and law is one of these social forces, very important. And of course, you could say the glue that keeps society together. A society in which there is no lawfulness, or rather a society which is you know fully consumed by unlawful activities, well, it ceases to be a society. It's just a group of people fighting against each other, without any rules or regulations or any respect for authority. So that's something that we cannot have. And so, of course, law is made up of rules, and these have to be backed up by enforcement. And we'll look at some of these aspects as we continue with the lectures in this course. So, rule of law is this very important element that helps to, sort of understand how laws are made and how they are applicable. Of course, laws need to be fully applicable to everybody equally. So there's nobody higher than the law or lower than the law. In the eyes of law, everybody is seen as the same. So if you don't have this sort of a system in place, then free trade as we know it cannot take place. Law is especially visible when we look at property and the management of property. So law guarantees your rights in resources, and without these incentives, there is no reason why anybody would want to keep property at all. So when you look at property, especially as you advance further in this law school bachelor program, you will understand that whether it's intellectual property law, competition law, family law, in all of these, property is a very important feature, and so law deals with all of these aspects. So property, as we can see over here from the notes, it's dealt with under, for example, contract law. So contract law dedicates a big chunk regarding the law of obligations and how property can be acquired, lost, sold, mortgaged, leased, exchanged, etc. Then under criminal law, we also see that property law is sort of covered over here, because under criminal law, if you steal property that belongs to somebody else, then that is illegal. Similarly, business organizations are enabled to understand how they can utilize private resources in groups. So what you have is a system whereby let's look for example multinational corporations. So they deal with big projects which require a lot of resources, and so you would have company law, for example, or business laws, which indicates how these resources can be managed. Some of the earliest examples of this could be seen, for example, in these big shipping companies that comprised the East India Shipping Company, the East India Company, the Dutch East Indies companies. The French had similar companies in the 14th and 15th and then 16th centuries. And what they dealt with was the very beginning of company law as we understand it, shareholding patterns, and the idea that many people can get together, and these are called shareholders, and they contribute money to a particular venture of a company, and in return for that they get shares, and then these shares entitle them to dividends. These shares can be easily traded, and at the same time the company is able to secure funding from hundreds of thousands of people, individuals, and the company can use that funding to execute its purpose, whether it's buying and equipping a ship so that it can be sent to Asia to pick up spices or whatever and bring them back to Europe so that they can be traded, all sort of things. These come under business law, and Companies Act deals with a lot of these aspects. So you have shareholders, you have the laws of incorporation of companies, you have private companies, public companies, and all of these are, as you can understand, specifically dealt with by the law, in this case the company's law, and it deals with law and the management of resources. Similarly, you have regulatory laws, and again these tell you how you can spend your time and effort on your property, how you cannot. So for example, you have something in a simplistic sense. Let's say you buy a flat in the old town in Tallinn, and there are a lot of restrictions because many of these are houses from the 14th or 15th century, and so you have regulations which indicate what you can do with these houses, what you cannot do, what color you can put on the walls, what sort of windows you can have, wooden, not plastic, what sort of roof material you can use, etc., etc. Regulation also deals, for example, with the transfer of technology block exemption regulation, and this would be a regulation which indicates how intellectual property law and competition law can coexist. And again, this would specify, for example, what sort of activities are pro-consumer, what sort of activities are deemed by the law as anti-competition, etc., etc. You'll learn more about this in the course of your studies over here. So along with this then come security laws, environmental laws, and a host of other laws which deal with pollution, and securities law deals with securities, whether these are in the form of shareholdings or even other financial instruments. So all of these are instances of how law indicates or dictates what should be the way to deal with property. So coming over now to philosophy of law, well, this is a very interesting topic. At the same time, some people find it very boring. Well, it's of course extremely historical, and it deals with some very deep questions, and that's how philosophy is generally as a subject. And they ask very deep questions. Who are you? And what is your role in society? And that's not a simple answer. From a science perspective, for example, well, your role in this world is to make sure that you can pass on your healthy genes to the next generation. Well, that's hardcore sciences, yes, biology and stuff like that. In social sciences, we go more into philosophical aspects as to what does it mean when you say that you are a human being, or you are a national, or you have certain rights or certain obligations under the laws. And so these are very deep questions. Of course, they also delve with aspects like morality and ethics, and some of these issues can have a lot of wide-ranging questions over here. So as I spoke, I think in the previous lecture, you can have laws which make perfect sense but which are immoral. And in this situation, how would you deal with a law which is perfect on paper but which is horrible in its terms and consequences? So the ancient Greeks, of course, looked at this, well, initially from a general philosophy point of view, and then law slowly evolved out of those rules and ideas that they came up with. And so law then developed into its own particular branch. And you can see more about that in the notes and of course the questions that deal with rules of behavior, ethics, etc., etc. So, well, as I had spoken, I think in the past, ethics and legal ethics can be two different things. So you have to be very careful about this. So, for example, the law may indicate in some countries that the age of consent for having sexual relations could be 14 years, or it could be 18 years, or it could be 21 years. Now, what happens if you have sex with somebody who is 13 years and 360 days old? So just 5 days less than becoming 14 years old. Or similarly, in the case of 18, if that is the limit, and you have a law which says that, or 16 or 21 or whatever, and you have a law which says this is the deadline, and let's say you are 3 days short of that deadline. I mean, is that really such a problem now? Well, under the law, if that's the minimum limit, that's it. If you are under that limit, even by a day, then you are in trouble. If you are above that limit, of course, you have no issues at all. So these are aspects of law which have to be dealt with sometimes, and sometimes law can seem to be very cruel, but then you have these artificial deadlines and you have to really respect these deadlines. But what law does is it puts these deadlines at the least, very bottom, bare minimum. So if you can't go above that bare minimum, then unfortunately, it's really a bad thing, and you have broken the law. But on the other hand, if you were to look at, for example, ethics or morality, well, if you look at how religion imposes certain deadlines or limitations, then they are at a much higher level than what law would indicate. So this is something to be careful about, especially because, as you would know, initially the law and the state, especially in Europe, Western Europe, were at the same level. They were in the same boat in that sense. So that would not be a very good combination of things in some situations. So you have some of the earlier views, and of course we're not talking about Aristotle, that was already dealt with previously, but now we are dealing with people from, say, the 13th century onwards, and so they have different laws which you can read about. So there is Thomas Aquinas, so that's one person, a philosopher, and well, they try to think of law in the terms of how the Greeks and then the Romans had exploded until they sort of disappeared from the scene. And so you have different aspects of law, jus civil and jus gentium, and these concepts which the Romans applied to everyday life. And so natural law was also seen as an important element of this, and that was something which was developed further. Another important aspect that you can see already is an influential concept of the social contract. And the social contract was quite interesting in the sense that it said, well, if you perform your duty and you do your obligations properly, then society or the social system will protect you. So if you follow the rules, so you are at the red light and the light turns green, and so you drive or you walk on the zebra crossing, and if in that moment of time somebody was to let's say cross the road or drive over you, then in that situation, Well, you did your duty, right? You are supposed to only cross the zebra crossing when it's a green light for pedestrians, and so you did that. And if some car owner, driver now drives over you, then of course, well, the law will punish this person now, because obviously the driver has broken the rule and not you. You followed the rule, the other person did not follow the rule, and now, well, the law would provide protection to you. So this is a social contract, and you see this a lot in many streams of philosophical thought. So, well, there is Hobbes, of course, very early as a positivist, and a positivist would be somebody who talks about positive laws, and positive laws could loosely be considered as laws which are now actually put down in a positive sense, in a book, put down in a specific way. And now these laws have been debated, thought about, and so now positive laws would have to be obeyed because of the fact that they have been laid down and in a book or in a statute or wherever. Again, a very loose definition of these very vital concepts. But as I said, in the past, this is not a philosophy course. This is a law course, and lawyers tend to see philosophy in a different light sometimes. So all of the concepts I'll be talking about would be from a legal perspective purely. In some of the previous classes, I've had some philosophy students getting upset because of my frivolous handling of philosophical aspects in the classroom. But remember, this is a law course, and we look at all of these issues purely from a legal viewpoint. So then there is John Locke, and then there is Rousseau, and they had a lot of these concepts which were very fascinating at that point of time. And some of these legal concepts, as you can imagine, even led to social revolutions. And the classic example of that would be the French Revolution. And well, also, for instance, you could look at the American Revolution, and all of these had deep philosophical issues at mind over here. So you see a lot of this philosophical thought process which deals with laws, and you also see this in very controversial terms. For example, in the American context, the United States of America, and they have some very simplistic viewpoints about certain things. So for example, a government which governs least governs best. Well, there are certain merits, of course, to such free thinking. Well, how possible is it in modern living is of course sometimes debatable. So some of the issues with the American Constitution, for example, freedom of speech. Well, freedom of speech would imply not only to what was written or printed in those early years, but also would apply to emails as of, in today's world, or your conversations in WhatsApp or Skype or things like that. Now, this is a very deep concept because similarly, there are some proponents who say that the Second Amendment of the US Constitution, which guarantees the right to bear arms under certain situations, well, of course, there's a whole big debate about these things. The question that sometimes arises is, what sort of arms were they dealing with? So when some people, some modern gun owners say that no, arms means anything, it includes a modern machine gun. And then there are others who would say, no, arms meant arms in the 18th century. So, those very slow, cumbersome weapons. Then there are people who would say in that situation, if that is the perfect way of explaining how to interpret these old constitutional amendments or clauses, then similarly, how can freedom of speech, which was drafted in the 18th century, apply to emails? Because you didn't have computers at that point of time. Now, these are, as you can see, very debatable issues. And again, in this class, I don't take a side over here. I'm not pro something or anti something. My point here is I want to try to make you think about how all of these issues have a deep philosophical impact. So philosophical impacts can of course cause a lot of controversies, and in the worst case scenarios, like in the unfortunate situation of the poor French king and queen, well, you could lose your head also if you're not careful in dealing with social revolutions. And law, of course, plays a very important role in molding the not only the opinion of society, but also in forming or giving birth to a new social system. Then in the 19th century, one of the key aspects that are visible is codification of laws. And this started really from the Napoleonic codes, for example, where everything should now be in a book, and if it's not in that book, then it's not illegal. As simple as that. So everything, whether it's inheritance, whether it's marriage, whether it's nationality, citizenship, whether it's your rights of obligations, contracts law, duties, everything should be in one book. Property laws, movable, immovable, everything, so that not only can people read everything and understand it in a simple sense, so that the law is demystified, but also that law is now clarified. The legislature has decided what the law will be, and now the role of the judges is to interpret the laws and to implement the laws, not to create the laws. This, of course, causes friction with other legal systems like the common law system that we'll talk about next time, whereby you have a situation where judges create laws. That's a very controversial issue now. So of course, again, philosophical undercurrents to all of these issues. And so we have Austin, for example, and his theories. And of course, some of the issues that came up was that sometimes these theories work at the individual level. So you are a citizen, I am a citizen, or I'm a resident, you are a resident, and we are here in Estonia. And of course, Estonian laws would govern what I can do to you or what you can do to me as individuals, or again as entities registered in Estonia, whether you are a company or whatever. And then you contrast that with what about Estonia's relations with Latvia or with Russia or with South Africa or Australia or with Chile or Japan? Could you now say that what applies to the relationship in the legal sense between you and me as individuals would also apply in the same context as that with nations? Can a nation be on the same level as an individual? And so already you can see how national law is now transposed to international law. And of course, there are big problems here. One of the biggest issues would be, I like your new iPhone, so I punch you in the face and I steal your iPhone from you. Well, of course, the law would say I've done a bad thing and I should be punished under criminal law. But could you now take this to the next level and say, all right, well, a big country punches a small country and takes a small piece away from the small country. Could you now say that, oh, well, the big country should be punished? How do you punish the big country? Under what legal system? Who is the international policeman or woman who will deal with this? Which international court will deal with this issue? So again, these are all deep philosophical questions. And the problem with theories then is if some things don't add up, then it's not a good theory. So for example, 1 plus 1 is equal to 2. That's a theory, right? And it works because those are very sound principles. But if you say 1 plus 1 is equal to 11, how do you prove that? And of course, if that cannot work out, then obviously the theory is good and valid. But if 1 plus 1 is equal to 2 and 1 plus 1 is also equal to 11, then there's something seriously wrong with that theory because obviously it's giving wrong answers. So these are all these debates that deal with philosophies of law. And then in the 20th century, of course, you have Kelsen, the Austrian jurist, and he had some very, very important concepts, especially the Grundnorm, which is the very basic thing. Of course, what this would ask is, what is the most basic aspect of your country? You take it down more and more and more and more. It's like you have an element, you have a compound, H2O, and then you have atoms that comprise these. So that's hydrogen and oxygen, and then hydrogen or oxygen would then comprise of electrons, positrons, neutrons, all of that stuff. And then you come down to the atomic level and the micro subatomic level, And so the question that comes down is the Grundnorm. What is the most basic element? And I mean, if you have a welfare state, what is the most basic element of a welfare state? Not the fancy stuff that the lawyers say, the politicians say, but the very basic thing. If you're a democracy, what is the Grundnorm? What is the most basic part of a democracy? What's the most bottomest, tiniest particular issue that you can deal with, which is the aspect of democracy? Would fundamental respect of human rights be the most important element of a democracy? You see, so these are all very deep philosophical questions. And then there was Hart, and Hart, of course, came up with his concept of pure positivism. And then came, well, Dworkin, again, a critic of Hart, who came up with his own theories. And then Rawls, and John Rawls, of course, came up with the concept of the veil of ignorance. And this is a very deep issue over here. Very often, for example, you look at the refugee crisis in Europe. So you have these hundreds, thousands, millions of refugees coming into Europe. And of course, those of us who are here, either as citizens or residents, may feel differently compared to those who are on the other side of the wall. And so, of course, a lot of the debate gets pushed around in that context. But what Rawls would say is, your view about refugees is maybe colored by the fact that you are of a particular nationality, and you were born here, your family is from here, so you have money and you have a job, and you don't see why you should share it with anybody else. And of course, the refugee on the other side of the wall maybe thinks in a different sense. So Rawls would say that to get a fair understanding of where things stand, maybe you should forget that you are white or black, rich or poor, citizen or non-citizen. And when you look at things from that plain slate, then of course things look very, very different. Basically, you're removing your personal biases. Is that a good thing? Is that a bad thing? Again, I'm not here to brainwash you. So that's something you have to figure out yourself. And then, because in this course and in most of my classes, we tend to have a lot of Finnish students. So I threw in a bit of the Scandinavian and Finnish modern philosophical views as well. So you can read some of these things. Again, extremely simplistic, not too deep. So don't get very fancy ideas. You will not become a philosopher of law after this lecture, all right? So hold on to your horses. And then, of course, public international law, as I spoke a bit about some of the problems that arise when we look at legal theories and philosophical thoughts and how they apply in the context of course, a more international arena. But public international law is very important because it covers a wide variety of things. Not only, for example, your uncle from the UK who sends you a letter and how it reaches you finally in your house in Estonia or in Finland, but also when you want to get married to somebody who is from a different country, a different continent. All of these are very deep issues, and public international law is a very important aspect of these issues. And so, these are things that international law and public international law, private international law deal with. And of course, the theories need to synchronize with what issues are related with individuals, and then how these can be taken to a higher international stage. Having spoken about all of this, now is the time to talk about classifications of law. Very important. As a young law student, this is an area of law that you should really be very well versed with, and you should know that there are different types of laws, and there are at least 4 different categories that you should be very careful about. Number 1 is civil law and criminal law, and this is a very important distinction. I'll try to talk more about this, of course, when we deal with criminal law and also with civil law issues. Now, civil law is something which is between you and me. as individuals, all right? And criminal law is where the state comes in somehow. So the state gets involved. So criminal law is more easier to explain than civil law. For example, let's say I punch you, yeah? So I hit you, your teeth come out, or you hit me and my teeth come out. And now what's happened over here, it's not just something between you and me. You see, you're a student, I'm your lecturer, we are in a public university. It's not a boxing ring, and of course, we shouldn't go around punching people. And so, this does not just involve you and me, or your parents, or the dean's office, but it actually involves the state now, because there's obviously something wrong here in this relationship. Well, one of us is very violent, and the law would need to now make sure that the state sort of explains to us our roles and duties and obligations, and also punishes us for our wrongdoings, and also safeguards the weak from the poor. So you see, this is criminal law, and especially if somebody gets hurt, somebody gets your property gets damaged, in a criminal sense, I set fire to your car or something, then this would be under criminal law. Civil law, on the other hand, would be more of a contractual issue, a private dispute. So you pay fees and you enroll yourself here and you want to get a law degree, and at the end of 3 years we give you a degree in business administration. What the hell, I mean, that's not what you signed up for, right? You studied 3 years of law, you attended all my courses, you got all these crazy ideas about law, and at the end of 3 years you get a degree in Bachelor of Science with a specialization in chemistry. That's not what you paid for. And of course, this is now a private dispute which has serious consequences. The same would be for your car. So let's say you have a car and you turn the ignition on and there are sparks in the car and the car catches fire. Well, this was not done intentionally to kill you. It's more of a manufacturing fault, in which case, of course, it was a civil law issue now. Although you can have a situation where civil and criminal sort of intertwine, becomes a gray zone. So you have a manufacturing defect and somebody dies. So now you don't not only have a criminal investigation and a criminal lawsuit, because well, somebody has died, obviously, and somebody has to be punished for this. And at the same time, you also have a civil law dispute, in the sense that you can claim damages because you've lost a car, you almost lost your life, you have suffered mental trauma. And what you can have is, well, both of these running at the same time in a parallel sense. So this can be quite tricky sometimes. I hope to give you more examples in the course of our lectures over here. Next would be public law and private law. And again, private law is between the two of you, all right? You and me. So private law would be, for example, it's a contractual thing, law of obligations. I promise to pay you something, and in return for that, you agree to give me your iPhone, right? So we are buying and selling, and now you pay me the money, and I give you a brick, and of course that's not an iPhone. So we have a private dispute over here, and in that situation, well, it's a private law aspect. But public law would mean where you have duties and functions of public bodies and officials, and this is a very huge area. Public law would, for example, govern how would your Estonian degree be recognized in a different country within the European Union. So again, you see, this involves a lot of issues dealing with international and regional law systems. So that would be public and private. Then you have international law and domestic law. Again, well, this is a bit tricky. Domestic law is what deals with law in the Estonian context. And international law would now be law which is in a foreign context. So obviously you can see some overlap here with the previous paragraph. When I spoke about public and private law, well, public deals with public issues regarding the government and the state and you. And when you look at international law, of course, there's a lot of gray zone sometimes, because let's say the domestic law of Estonia or Finland says that gay marriages are not allowed, and anybody who indulges in a gay marriage would be hanged to death. Now, that may be a national law, but in the European context, it can't work because, first of all, under the Charter of the European Union and, of course, also the European Convention of Human Rights, capital punishment has been abolished. Well, yes, you do have situations in some countries like Poland, for example, where civil unions between same-sex couples are restricted. So you have a lot of these issues that come up, and an international and domestic law cannot always be easily, put in different boxes, because in the globalized world we live in, very often you have a lot of mix and match happening. But basically, domestic law is what the law is in your particular country, and international law would be on a more global level involving different countries. International law would then be covered through treaties or conventions, and the United Nations again would deal with international law. Lastly, you have substantive law and procedural law. It's a very important distinction that you have to keep in mind. So substantive law would be a situation where the law says, all right, this is the definition of theft, and so if you commit a theft, this is the punishment that you will suffer. The law may now also say that if 5 people get together to rob an individual, then of course the punishment may be 1 year extra more. What if 5 people rob an individual on a national highway? Well, again, you see, so the law would now indicate that this is a situation where you have to get extra punishment. What if a person hijacks a car? Well, yes, you are now stealing a car, you are kidnapping people, so the punishment for this would be 2 years. What if you hijack a plane with 400 passengers? Then, of course, punishment is again different. So the law substantially outlines what each offense is and what the punishment is. But procedural law is what dictates how the procedure works. And then this is a very complicated issue because, for example, procedural law would indicate what sort of evidence can a court of law accept. So if I'm a police officer and I've charged you with a certain crime, and now to make you to confess to your crime, I beat you up, and at the end of the beating you say, yes, you confess, you are a thief. Would such evidence be acceptable in a court of law? Now that's procedural law. Another very important aspect of procedural law, which I've put up over here, is the statute of limitation and the Nazi era art theft and the German law of limitation. And this is an area which sometimes people get very confused about. So when you are dealing with the law, there are certain time limits. And after those time limits, you can't really do anything, even though you are in the right. So for example, let's say I fail you in this course. So you have 6 months, you have a year, you have 2 years, to take this issue up with the dean's office, the rector's office, the court of law or something. You can't come back after 25 years and say, well, 25 years ago when I was young, I was a student and this guy called Pawan failed me in a course and now I want to get that sorted out. And that was 25 years ago. That's a long period of time. So that's a law of limitation, and you have to be very careful about this. So procedural laws deal especially with how the courts will work, what sort of evidence they will take. So evidence law, you have criminal procedure code, civil procedure code, what are essential parties, who are the essential parties to a suit, who should be together. Procedural law would indicate that if I want to divorce my wife, who can file the divorce application? Well, obviously not you, because you have nothing to do with me. Can my children file a divorce application on behalf of my wife? No. I'm married to my wife. So a divorce between me and my wife would be something that can only be dealt on the application of either of us, me or my wife. My father-in-law, my grandparents, they have no role in this. So these are certain things to be careful about, and we stop